Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning and welcome to our Spring Forward Legal Updates webinar series. This is our 10th and the last one of 2021. And today we're discussing the top 5 employment law mistakes to avoid in 2022. And what a year it's been. So I'm going to get right to it. We're hoping to gather all the stuff from 2021 of mistakes to think about and get you ready for 2022. My name is Lisa Stam, one of the lawyers at SpringLaw. We usually pair up on our webinars, but I'm flying solo today because of all of the end of year mediations and court appearances and client meetings this morning that the team has in these final weeks before the holidays. Plus, I love to talk about employment contracts because I just think that's the most effective way for a employer to save costs and hassles and headaches. So I'm happy to just talk about contracts for the next 30 minutes and employment law and the different employment law mistakes that you can all avoid for 2022. If you are one of our clients, you already know that we are contracts and employment lawyers at our virtual law firm based out of Ontario. For those of you that are new and new on this panel or new on this webinar, welcome to our small employer community and to our webinars. Please feel free to download the handouts that are in the box on the software here, mistakes-to-avoid.pdf. And if you would like any other information about our law firm, please feel free to visit our website at springlaw.ca, where we have a variety of resources, including our award-winning weekly blogs. We post a blog every Wednesday morning about whatever the most recent updates are. Our free employer guide for our employer COVID guide that we update regularly, and that requires a lot of updates. And we're heading into another after almost 2 years, heading into another round of probably some new rules coming out from the government right now. There's a link to our monthly newsletter, information about our innovative subscription program for employers on our website, and our new and affordable DIY workplace law bundle that we've just put out last week, and I'll tell you a bit more about in a bit. Okay, today is all about legal information, not legal advice. We're lawyers, so no talk is complete without some sort of disclaimer. Here's more disclaimer. We can't help ourselves, but everything we say today is legal information, not advice. And to check in once in a while for any information you get today, it keeps getting updated, especially in the world of COVID. So everything is good to go and current as of today. Okay, this is what I'm going to talk about today. Our webinars are 30 minutes. I'm going to stick to the 30 minutes so that people can pop in and then get back to their desk to finish all their end of the year busy schedules. So today I'm going to talk about the top 5 employment law mistakes to avoid in 22. So carefree contract terms and processes is mistake number 5. Mistake number 4 is firing for cause when there isn't cause. Mistake number 3, disciplining people before investigating. Number 2, infrequent and crappy performance reviews. And number 1, termination clause troubles, especially after all the changes in 2021. I will embed ongoing pandemic and COVID-related issues, including, hybrid, remote, that kind of thing, all into the topics as I go through everything, rather than us having yet another full session on COVID. I know that the pandemic's far from over, but everyone's getting pretty sick of COVID. I know that, but there are other issues to still attend to, and I want to deal with that today. we're going to run a poll. I just want to get a sense of the people that are on. I had a couple of questions. So the poll is now open. I can't say I'm an expert on how to run a poll. So Jessica Raposo behind the scenes is helping me out. And the 3 questions that she's putting out, if I can get you all to just give us your quick answers or yes, no answers. Number 1, do you think your contract termination sections are enforceable right now? I asked that question because I want to get a sense of where people's head are at with all the changes that employment law has driven this year. Number 2, do you have a hard time keeping up with employment law changes in 2021? I'm guessing that many of us will all have the same answer on that one. And then number 3, do most of your candidates counter propose terms when you hand them a contract offer at the beginning? I'm curious whether or not people, there tends to be a ton of counter proposals, or do people just sort of accept the terms that you put in front of them? Okay, I'm hoping that this all worked, these questions, and then, okay, so it's up. I'm seeing it. Okay, I have some answers here. So for question number 1, 74% said yes, 26% said no. So 74% said yes, you think your contracts are enforceable. That's awesome. Okay, good. And then for the next question, it was 100% for number 2. That's awesome. Yeah, fair enough. And then number 3, do most of your candidates counter propose, yes or no? And what was the answer to that one? Number 3 is 50-50. That's interesting. Okay, so half the time, and I think this is probably interesting for you, the audience, as well. About half the time, employees tend to push back on contract terms. So that's actually just a good piece of information to know. Okay, let's jump in. Mistake number 5 to avoid: carefree contract terms and processes. This is how I wish that we could be, drafting all our contracts, but it's not. We sit at a desk for many long hours a day. Okay, mistake number 5. First and foremost, employment offers and contracts can really reflect your company culture and values. And just as a little FYI, I ran across this even this week with a client. An employment offer letter is a contract. So whatever's in that offer, it might be the cover page of a super long, complicated piece of legalese, or it might be the whole thing. It might be 8 pages of an offer letter that sets out all the terms of compensation, etc. All of that is still going to be deemed the contract at law. So your offer letters, your contracts, these all tell your candidates and your employees who you are, what matters. It's an opportunity for discussion around compensation and vacations. But from a business point of view, it's also a really important chance to have that calm conversation now when everybody's friends about what an exit looks like at your company. And I think if I can somehow get one point across as an employment lawyer, the key moment is right now when an offer letter is going out, or if you're discussing new contract terms with an existing employee, what that exit would look like when everyone's friends. I think it saves so much money and hassle and headaches down the road. If there is no contract in place, or if the contract provisions, especially that termination provision, is out of date and not enforceable, the courts will simply imply a contract. So and this is especially for anyone who has a US parent or HR headquarters that you report into. In Canada, there's always an employment relationship, whether or not you have a written piece of paper about it. So the courts will simply imply contract terms based on years and years of case law that are always going to be very employee friendly and generous. So contracts are a chance to really have a compromise and have mutual understanding and expectations, and to really set the tone for what especially what the termination would look like, but just how these terms are going to be negotiated. So careful terms. A careful step is to also ensure that the contract is signed before anyone starts, so that you don't have to then get some sort of signing bonus or consideration afterwards. So carefully rolling out your contracts is also an important step and a mistake to avoid. The bottom line is careful contracts save companies money, period. I just think that's an important factor. And if you have a US parent, it often is the opposite in the States. A pain in the neck that can just open up a big can of worms. Here, that can of worms is open and wide in the first place because of how our common law works. So that's mistake number one, is having carefree contracts that aren't carefully and deliberately written and that are carefully rolled out. Okay, mistake number two, when employers who fire for cause when there actually isn't cause. I would say this is our number four biggest mistake that we run into and that we have to help our clients out with. So in our case law in Canada, and you've probably heard us say this before, the termination is referred to as the capital punishment of the workplace. So someone who's fired, it's in our case law, it's right, our Supreme Court of Canada has talked about how firing someone is, one of the worst things that you can do in the workplace, and that it requires notice or pay in lieu of notice the vast majority of time. For a just cause termination, i.e. when you can fire someone without giving any sort of notice or pay because they've just done something so bad, it's very rare and the threshold is very high. You really need evidence, and really clear, excellent evidence to establish cause. And specific evidence. Usually if it's any sort of, he said, she said kind of thing, or if it's, conversation that went awry and there's no witnesses, all of that will be tricky. You're better off to have something specific like a video of someone stealing money, or an email exchange where someone very deliberately, diverted a client to, their own company, or something very specific where they're ideally a monetary loss is or some sort of breach of trust that is so profound that it renders the employment relationship irreparable, to quote case law. So usually there's no cause, usually. So let's talk about without cause. What we often have is, not often, thankfully, but we do have clients that will come to us and say, oh, by the way, so-and-so did all kinds of terrible things. We fired them for cause because it's so terrible. What do we do now? They've come back with a letter from their lawyer. It is so much easier to just get legal advice ahead of time, and almost always it's more cost effective and simply cheaper for a company to fire without cause, offer up some sort of minimum package. If you've got a good contract in place, just give that minimum amount. And then really there's not much that the employee can do. You've satisfied your contractual obligations. You don't need to give a heck of a lot more at all. And then you're done. There's nothing for them to sue about. Taking very aggressive, principled positions, I'm sorry, but it's often very expensive. And it's noble, it's important, and there are times when it is, you need to send the message for the rest of the employees that this kind of behavior is not condoned. But more often than not, we have clients that regret going down that path and would rather just deal with it in a more cost-effective way. And also, sorry, but non-competes in your contracts now, as of the last few weeks, are no longer enforceable. Bill 27 has passed in Ontario, meaning anyone below the C-suite, so your CEOs and your high-end executives, you just can't enforce any non-competes anymore. You still can enforce a non-solicitation provision in your contracts. So employees still can't go off and steal your clients or steal your employees. They can't solicit those. But It is now law that they cannot be restricted from working elsewhere. It's a free market and it's contrary to public interest to enforce a non-compete. We haven't gotten any case law on this new law yet. It's all very new. I'm sure that some parameters will be built around it. I would say for now, just stay tuned for early 2022, where we can start to, flesh out exactly what Bill 27 means. The reality is, in most of the situations, you couldn't enforce a non-compete in Canada anyways. It's the onus is on the employer to prove that it's reasonable and necessary, and the courts love to set it aside because they want to balance that employer's right with the employee's ability to work. So I'm not convinced this is going to be a giant shift in our law. But it does mean in your contracts, if you want to fire someone for cause because of a non-compete, I would definitely pause and get some legal advice on that. Okay, mistake number 3 that we see, disciplining people before investigating. This one is hard, and I run across employers doing it all the time without realizing they're doing it. So HR law in general, we know it's very human, it's very emotional, it's very messy. There's always 2 sides to every story. And so you just, you never know what the other side of the facts are until you get all of it. Now, we have all these important legal principles in Canada. Everyone is innocent until proven guilty. That's in criminal law, of course, but even in civil law, in the employment law world, when you have a situation in front of you, it's critical to just hear both sides of the story, especially if it's anything around harassment or workplace violence. There is a very specific obligation on the employer now to make sure that they are proactively investigating any allegations or complaints that come forward around harassment and violence. And this means asking people. It doesn't always mean pulling in a very expensive, giant external investigator at all. It just means inquiring, asking people what's going on and what's the other side of the story. For many situations, some sort of more formal investigation is required, but not always. Day-to-day HR law involves investigating all the time, just inquiring, asking. When it comes down to case law and where employers get into trouble in terminations is when process wasn't followed. It really is a good 50% of employment law, just following the internal policies and procedures and making sure that you're not just jumping straight to the substantive decision or outcome that your gut is telling you or your brain has told you after an investigation. Following the steps in a process is half of what a court's going to be looking at. So it's important to do this. The pandemic has just turned everything upside down, right? Different types of work environments. People are stressed out, and it's more complex right now for the world of owner-operators in HR, where your people are stretched, and you as owners are stretched, and everybody has their own mental health needs right now. But investigating and hearing both sides of the story will eliminate so much of the work we do every day. So mistake number 3 would be to doing any sort of disciplining without looking into it first. Mistake number 2 that we see, infrequent and crappy performance reviews. We often hear about these from the employee side of the fence, I would say. Employers aren't going to, brag about their crappy performance reviews, but annual reviews are simply not enough. People need to hear feedback as they go. For all the employers that are listening, we also represent employees and executives. And what I can tell you is that by far the biggest concern that employees have, or the biggest trigger that employees have when they're angry and emotionally distraught about something happening at the workplace is they didn't feel like they were heard, and they feel like it was unfair. And so, or that they were surprised and ambushed by the perspective of the employer. And just having regular check-ins with them, whether it's quarterly, shorter reviews to supplement a full-fledged annual compensation review. I'm not an HR expert. I do employment law. So for anyone who's an HR expert, I know I'm preaching to the converted already. But what I see is the impact. When people feel ambushed and surprised, employers are surprised that they're surprised. But it happens so much. And just having regular, even brief performance reviews really make the difference. And COVID has just exacerbated all of this. Employees just need to be heard. Okay, number one mistake that we're seeing is just everything around termination clauses. It really remains one of the number one costs to employers. Most of the case law is about termination and what sort of reasonable notice someone should have gotten in the absence of a contract. You know, that is such a giant, huge percentage of what we do all the time. It's what generates the revenue of our firm. So having good termination clauses in place really can be the game changer for workplaces. And oh my God, there's so many changes in 2021 and 2020. Courts are quick to set aside termination provisions if they are not following a bunch of the the things that have come out in the case law over the last couple of years. The other piece, in addition to just legal compliance, is it brings this certainty and allows for a conversation about mutual expectations up front that really minimizes all those battles on exit. The reality is our case law is pretty clear that a terminated employee is going to get somewhere between 3 to 5 weeks of notice or pay in lieu of notice for every year of service. We kind of know what that should entail already. So much of employment law shouldn't be litigated because we kind of know what they should be getting on termination. And if there's clarity in a contract, then even if the employer has to plug their nose and pay a wee bit more than what they would like, it's going to be way cheaper than running a trial on it. That certainty can just bring this calm to the exit. It jacks down the emotions of the employee and lets them, move on faster from an emotional point of view, and really help eliminate so much of the battles. I don't mean to oversimplify it, but I really can't overstate how important dealing with terminations can really bring down costs. And even in a small workplace where you haven't had a termination in a while, it just takes one person to blow the budget for the year. So it really does matter. It can just really contain the termination liability to a reasonable compromise. Here's the other thing. Termination amounts in the case law reflect what a court would award after a trial. So that's after the employee and the employer have been battling each other for a year or two. It's after all the costs of discoveries and the pleadings, discoveries, mediation that maybe didn't go well, and just the headache and hassle. And then the trial itself, the legal fees there. So it's and the work and energy being diverted to it. So when you're looking at common law amounts, that's after all that. So for both parties, it's very reasonable to have a compromise in between the broadest common law amounts and the minimum employment standard act amounts on termination. And contracts should be some sort of middle ground of that. And if you don't have a good enforceable contract, it means you're looking at this broad general employment law amount. So it really is cost effective for an employer to just really pay attention to this. I think I've drilled this home. I think you got the message, but termination provisions. Here's some tips. Here are some of the main things that have come out over the last couple of years. Go check out your termination clause and do a quick self-audit to see if this is all in there. So the first one about needing your with cause magic words from the Employment Standards Act. They need to be in there in order to make sure the full termination clause works. This is the Wakesdale thing from 2 summers ago that knocked everything upside down and is fairly bonkers. And so what you need to have in there, it's from Regulation 288.01, Section 9, Sub 1.6 in the regulation. You can go on CanLII and look that up. But the words that you want to make sure are in your contract or a reference to this regulation is willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. You can ask us what that is after if you didn't catch that, but it's in Regulation 288.01. These words were not in the just cause or with cause section of the contract that was under review in that case, in the Wakesdale case. And what the court held is that because you didn't comply with the Employment Standards Act in the with cause section, you can't rely on the otherwise enforceable language in the without cause section. Knocked the whole thing out, and the employee who was fired without cause got common law because the section didn't include the with cause words. Now, cases are starting to come out that are interpreting this and building on this and citing it. It was appealed. Appeal was denied at the Supreme Court level. So for now, it's law. But most employers agree. It's kind of crazy, but it's what we have in place right now. The other thing to make sure that's in your termination clauses is a reference to benefits and other Employment Standard Act things that you need to continue during the notice period. And if you don't have that, the court will also set that aside because you've tried to contract out of ESA minimums. When you're offering up an amount above ESA and then you introduce a cap, so often you'll see things like, you will get 2 weeks of pay for every year of service inclusive of ESA up to a maximum of X number of than 8 months, because otherwise you're inadvertently contracting out of the maximum amount a person could get under the ESA. And finally, know thy market. And if you're offering a contract to like a senior executive in a very specialized role, and they're getting $200,000 a year and all kinds of equity, don't offer them only ESA minimums. You're only asking for a giant battle on termination. Look into what market is for that employee. ESA minimums really are frontline roles, like a teller at the no frills, right? Like that is intended to be a frontline kind of role for ESA minimums. So know your market to avoid those battles at the end. The last thing I just want to touch on before we wrap up is those who know our firm know that our firm's mission is to really get innovative and practical DIY legal tools into the hands of small employers beyond our traditional legal services. And I just want to quickly share with you this new DIY bundle that we put out last week that really is about helping employers get up to date for their for 2022. Given all of the changes this year, we tried to pull it all in together so that people can really just hit the ground running in January. So our lawyers wrote this. It's a DIY kit of the core documents that you need to get your contracts up to date and to have a good termination package ready to go. In the contract is probably the key focus here because it has all the current terms that are up to date as of today, but who knows tomorrow, but we will continue to keep it up to date. It also includes 2 really detailed employer guides that set out all the law. A lot of what I talked about today is in there. Some practical tips, a bunch of checklists 3 checklists around, your terminations, your hiring, what all the provisions should include. So it's all included in this kit. That's $4.99, and you can just go on our website. And if you're interested in purchasing that, you can go straight to the website. As a final practice point, here are different ways. If I'm genuinely concerned about trying to have cost-effective or affordable ways for employers to do a quick audit of their contracts and get ready for 2022. So here are different ways to DIY it in a cost-effective way. You're always welcome to give us a call, and we can look at your contract and do one-on-one legal services for a regular hourly rate, or here's just another option for you. Get the new contract, and you can cross-reference it with your existing templates and just do the work internally yourself. The other option is to get the new contract template for your new hires, for people that you're planning to pull in early 2022. You don't have to have all of your employees' contracts look identical. You need to be equitable between your contracts. You can't, pay your men more than your women and all of that. But the actual format of your contracts don't need to be the same. And so it's okay to just start fresh in 2022 with a new format, for example, and know that your 30-year employee, you're not even going to touch their contract, because negotiating that termination provision is going to be bananas. A third option is to use a new contract as a head start. Populate it with all your own company's values and details, and then seek one-on-one legal review, and that will help bring down the cost too, because you're not you've got that head start of the heavy lifting that you can do on your own end already. Okay, that is concludes our webinar for today. I know some questions did come through, and I am keen to stick to the half hour today. If you do have any other questions that come out of this session, please just feel free to contact any one of us. Here's all of our email addresses. Our next webinar will be in February 2022. We have our strategy retreat in January, and we're all sort of settling back in after the holidays, so we usually do our first New Year one in February. The topic is to be determined, depending on what the heck the pandemic brings us. In the olden days, we had the whole year mapped out, but that's we've stopped doing that because we want to make sure our sessions are topical for what's going on with the changes in employment law given the pandemic. For more information about us, come to our website, springlaw.ca. I hope you're following us on social already. Facebook, Twitter, LinkedIn, Instagram, our YouTube channel. Feel free to sign up for our monthly newsletter to keep up to date with all of the latest employment law updates. That's it. Thanks for joining us today, and we hope you have a wonderful and a safe holiday. I know the numbers are getting stupid again, so I hope you all stay safe, full of some amazing rest and relaxation as well. See you in January.